palpably innocent person who happens to be exceptionally media-friendly. Unless Interpol can show that it is serious about applying its own rules, Interpol will then suffer at the hands of the US Congress, which pays 15% and rising of Interpol's budget. In short, if Interpol...
Law, civil litigation, criminal procedure. So, Camilla, you're very welcome. Let's just move the...
Thank you, Pavel. Good afternoon, ladies and gentlemen, dear colleagues. There is an old saying that power corrupts, request by Interpol, which is a prima facie control, and if that control fails, and as the practice shows it often does, the posterior control, the control that must be put in place, at least theoretically, by Interpol once the red notice is issued and its political character is claimed by the person who is wanted. NCB, a National Central Bureau, refers to a filter, and that preliminary filter exists within the rules of Interpol. Where can we find this preliminary filter, and how is it implemented in practice? On what is it based? The key word to this question, the key word in the preliminary control is the purpose. I will start with the Interpol Rules of Data Processing. It is Article 10, Paragraph 1 of Interpol's Rules of Data Processing. And I quote, Article 10, Paragraph 1 provides that the processing of data in the Interpol information system may only be carried out for a given explicit purpose which is in conformity with the organization's aims on one hand and on General Secretariat on the other hand. Moreover, Article 74, Paragraph 2.a of Interpol Rules of Data Processing says that the General Secretariat is responsible for checking the compliance of all notice requests with the present rules, and Article 10, Paragraph 4 completes this requirement by saying that the General Secretary National Rules of Data Processing, according to which red notices are published at the request of an NCB in order to seek the location of a wanted person, to arrest or restrict his movement for the purpose of extradition, surrender, or similar lawful action. So, whilst Interpol legal documents establish minimum criteria that need to be met for a red notice to be published, such as serious ordinary crime, penalty threshold, etc., the Interpol's rules are totally silent as to the test that Interpol shall apply in order to see if the red notice is abusive or, on the contrary, is in conformity with its rules, including with Article 3 of its Constitution. Thus, it is very much unclear what test does Interpol in fact apply in practice. There has been some doctrine, some scholars who have pointed out on the fact that the difficulty comes from the fact that the threshold used by Interpol is much higher than the threshold that is used by national courts or international jurisdictions like European Court of Human Rights. I must say that I quite disagree with this opinion because there are no reasons to presume that the threshold that is used by Interpol to appreciate, to evaluate the political character of the red notice, we have no indication as to that threshold. So there are no reasons to believe that the threshold is higher or lower or is the same. And to avoid any speculation, I would just say that the only thing that we know about the test that Interpol applies is the very poor information that results from the letters that the Commission for Control of Interpol Files, the CCF, sends to lawyers once they file the request on behalf of their clients, claiming that there is an abuse, that this is political, and the CCF tends to reply that it is satisfied or unsatisfied about the predominantly political test. So the only thing that we know about the criteria that are used by the CCF Commission is this mysterious, predominantly political character. But once again, to avoid any speculation, it does not seem to me that the predominantly political character is more severe than the political offense that is used by courts, by national courts, or by ECHR, the European Court of Human Rights, for example. So to put away this test about which we don't know much, I would say that the problem comes not from the substance of the test, but from the method, the way that this test is applied. And I think that is where the deficiency and the flaws come from. The underlying reason for this deficiency, I think, is much deeper than just the political game. It is the entire ideology of the system, the ideology of the Interpol system that relies upon the faith in the good intentions of the state. And as my colleague Ted just highlighted, and I very much agree with this expression, he said that there is a presumption of national quality of justice, I think, of national quality of the requesting state. There is indeed this presumption, the belief that a requesting state that sends a request does it with a good intention. Indeed, this presumption of good faith has created this major loophole in the system of Interpol, from which the totalitarian states have been benefiting and have used in order to transform the police cooperation into their preferred tool to fetch the political rivals. The question is then, once the harm is done, how to remedy the harm? And this brings me to the second part of my analysis, which is how to remedy once the red notice is issued. I will go back again to the foundation of Interpol and its core legal documents, and I will quote another article, Article 81, Paragraph 2 of the Interpol Rules of Processing of Data. And the Article 81, Paragraph 2, once again goes back to the purpose of Interpol's red notice. Article 82, Paragraph 2 explicitly states that an NCB shall withdraw its cooperation request and ask the General Secretariat to cancel the notice immediately once the purpose of this request has been achieved. And if the National Central Bureau fails to ask to withdraw the red notice, then Article 81, Paragraph 3 requires the General Secretariat to do so if it considers that the purpose of the cooperation request, on the basis of which the notice was published, has been achieved, or if the notice no longer meets the conditions for publishing. So once again we go back to this important key issue, which is the purpose. And now we know that the criteria for the publication or for the withdrawal, so for the remedy, is to consider whether it has been achieved or not. Now, if the General Secretariat or the NCB fail to do so, and as I already said, in practice, they almost all the time they fail to do so, the only remedy that is left on the basis of Article 36 of the Constitution of Interpol is the CCF, the Commission for Control of Interpol's Files. However, most of the people present here know that in practice, arguing the political context of the case has been insufficient to convince the Commission of the abusive character of the red notice. Convincing the CCF being a very hard task, that made me think of other remedies we may seek in order to withdraw, to make the CCF withdraw the red notice. And once again, I think the reason for the CCF to be quite reluctant to give this subjective appreciation of the political character goes back to the increasing need to fight terrorism. And there has definitely been a severe movement on behalf of the CCF after September 11 events. Unfortunately, the recent events in Paris also show that fighting terrorism is still a problem, and every state is concerned, and everyone needs to put common efforts to cooperate and to fight against the terrorism for everyone's security. So Interpol's mission, which totally relies on member states' goodwill to cooperate, has been sort of stopped or slowed down by this necessity to cooperate in very severe, very grave matters like terrorism. So Interpol, for diplomatic reasons, has definitely been very reluctant, and I may say also hypocritical, and hence reluctant to give any subjective appreciation of the political nature of the cases. which pushed me to analyze the situation and suggest a more, I would say, objective argument or a technical argument, which is the achievement of the purpose. Because the ultimate goal is impossible, because one country has decided that the extradition is dangerous for the person and he will not face the guarantees of fair trial in the country where he is extradited. So the extradition will never be achieved, and the red notice, which is the mean to achieve this goal, is still maintained. However, we see that this has not totally convinced the CCF yet, although based on my practice, which I'll be very happy to share with you in a moment, it has shown some progress. So based on my practice, I will give you two scenarios, and I think it is very important to draw a line between these two scenarios. The first scenario is the classical one, when a person crosses a country, a border, a frontier, comes to a country, is arrested based on the red notice, and then stays the delay that is necessary for a country to receive the extradition request. Usually it is between 40 and 80 days, depending on the national legislation. I am actually defending a client before the CCF who is a former Russian Duma deputy, and I will not disclose his identity because the case is still pending. But I can tell you that the Russian Federation filed a request against him a few years ago, and he went to a third country where he got established with his family. And then as he went to a vacation for a few days to another country, thinking that nothing would happen, the red notice alert was flagged by the authorities as he was crossing the border, and he stayed for 50 days in a local prison. After that, there was a request that was sent and was rejected on a very firm basis that there are strong political grounds and he may not be extradited to the Russian Federation. The person went back to his new country of residence, and never took any risk to travel anymore, which has been more than 10 years now. I filed a request a few months ago, and we are expecting, I hope, a positive answer, because the reasoning that I use is the one that I just told you about, which is the purpose has been achieved, and there are strong grounds to believe that the decision of this court, national court, that rejected his extradition request based on political grounds, will be universally admitted. A, it will be admitted in the European Union because it was a European country, and B, it will be generally admitted because if one country thinks that this is a strongly political case, there are strong reasons to believe that another country will also decide so. And in any event, the red notice has achieved its purpose, so there is no reason to keep the person in the database. Because the main issue that the Interpol needs to decide here is the following: isn't the fact that the person's extradition has been rejected, isn't this fact the ultimate proof of the abuse? The second scenario, which I can tell you about, is the same case, but we add another element to the person's personal situation, is the asylum. I have recently prevailed in a case for a client who has been in the Interpol's database for 11 years, and I defended that person before the CCF. We recently got a favorable response, and her information, it's a lady, her information was removed from Interpol. Her extradition was sought by the Russian Federation in the UK, where she has a permanent residence. The United Kingdom denied the extradition by saying the following, I quote, "In respect of this particular case, I'm satisfied that it is so politically motivated that there is a substantial risk that the judges of the Moscow City Court would succumb to political interference in a way which would call into question their independence." A few lines later, the UK magistrate courts stated that, "For the reasons I have just given, I am satisfied that extradition in this case is barred under the UK law, in that the request for extradition is made for the purpose of prosecuting the person on account of its political opinions." Just a few months later, this person got a political asylum on behalf of the UK authorities. When I filed the case before the CCF, I mainly argued the non-refoulement principle. The non-refoulement is a very important principle of international law, which is the prohibition to return a person in any manner whatsoever to a country where the person faces a prosecution and because of which the person received a status of political refugee. This principle of non-refoulement has received a real promotion for the past, I would say, 20, 30 years. The promotion it's a very common way of saying that, but it applies to everyone, including international organizations, which Interpol is. The important move in the importance in the value of the non-refoulement principle has been played by the European Court of Human Rights. As you may know, the European Convention of Human Rights does not protect refugees. It is the Geneva Convention that does. But the European Court of Human Rights has integrated the non-refoulement principle into the scope of European Convention by under the cover of other principles that are protected, namely Article 3 of the Convention that prohibits torture and cruel treatment. For your interest, if you are interested, it is a landmark decision of July 7, 1989, which is ECHR decision Soering versus the United Kingdom. In the landmark decision of 1989, the ECHR held the UK liable for having violated the principle of non-refoulement because of the extradition of the refugee to a country because of which the person received the status of asylum. And the violation of this non-refoulement was based on Article 3 of the Convention, which is the prohibition of cruel treatment. Later on, the ECHR developed its case law by expanding the protection of the non-refoulement principle under the cover of Article 6 of the Convention, which is the right to a fair trial. And very recently, quite recently, I would say, it's been 10 years now, 2004, which is also a case against the UK, F. versus the UK. It's June 22, 2004 decision. The ECHR has rendered a very important decision by consecrating an obligation to guarantee the integrity of refugees. And the way it did it is under Article 1 of the European Convention of Human Rights. And Article 1 of European Convention guarantees the integrities of people not only on the territory of the state, but also on the territory of the state where the person is extradited. So the ECHR is willing to hold countries liable for extraditing refugees to the state where they may face persecution. So this quite solid argument, I would say, has probably convinced the CCF more than just the purpose. And we can definitely say that they're helping by keeping the CCF convinced and reminding them of the spirit of its rules, of the spirit of the cooperation, which must be done in conformity with the Universal Declaration of Human Rights. We shall stay optimistic, and we may pursue what we do every day by fighting the abusive red notices, by convincing Interpol that the ultimate proof of the abusive nature of the red notice is the denial of extradition request by one state on the basis of a risk to the integrity of a person. So we can only hope that good winds of change will start blowing and will blow stronger, and the legal value, the legal authority of judgments, the res judicata of a judgment that denies extradition will prevail over the request of totalitarian states to issue the red notices. Thank you for your attention.
Thank you, Camila. And let me introduce our third presenter. It's Alexander Smolansky. He is the head of research of the INTERPOL worldwide. Alexander was born in St. Petersburg and graduated from the St. Petersburg Aviation Academy and from the St. Petersburg School of Foreign Languages. He worked in the 80s as a translator of British and American literature. And since 1999, Alexander has been working in INTERPOL Worldwide, which is the information agency researching mass media and social networks of Russia and other post-Soviet countries. Alexander's research interest of the last several years is how political and social changes in Russia and the former Soviet Union countries are reflected in mass media and social networks. Alexander, please.
Thank you, Pavel. First of all, a little disclaimer. Contrary to my fellow panelists, I'm not an expert in Interpol at all. So if I do any mistake, please don't pay too much attention to that. And so what I'm going to say is, and to show, is just to show how Interpol as such is reflected in Russian mass media and in Russian social networks, and just try to check if the topic is really hot or not. If it really draws any interest of the readers of newspapers, of the users of social networks. And the research is done with the database called Integrum. And what Integrum does is the building up a sort of electronic portrait of the former USSR. So thousands and thousands of newspapers, magazines, archive over the last 25 years are stored on the servers, and billions of posts in social networks are monitored according to the topics which are interested to the researcher. And now what we're going to do to see how Interpol topic can be researched using this research tool. So altogether, what we are going to use is this service which is called Integrum Profi, and this is the world's largest electronic archive of all mass media of the former USSR countries. And this is this one, the first one. You know, I'm using iPhone for this presentation, so I cannot point the mouse pointer. Sorry for that. The second one is My Integrum, and what is that? You can set up the topic of monitoring, and the system 24/7 monitors the whole post-Soviet information space according to the topic of your interest, and withdraws the articles and any other materials which are relevant to your search criterions, and gives you the instruments for the analysis. The third one is Integrum Social Networks, and as I said, this is quite an effective tool to research how the topic of your interest is mirrored in social networks. So first of all, this is Integrum Profi, and this is some statistic of that, and archives going back to 25 years. The documents are in Russian, Ukrainian, and English. And let's just enter this research word, Interpol, or Interpol in English. And let's limit our research only in the last 12 months. So as you see, it's just 10 years. It's from 2005 until 2015. And as you see, the system shows first, and this is on the left-hand side, the overall picture, how Interpol is reflected in all post-Soviet media over the last 10 years. So you can easily see in what groups of mass media Interpol is more or less actively mirrored. On the right, there is a table which shows specifically from what publication go these materials, go these documents. So you can immediately see what newspapers and magazines are most active in reporting the issues regarding Interpol. So altogether, as you see, let's just compare how two other international organizations are mirrored in or represented in Russian in Russian mass media. So let's take NATO, for example. As you see, 2,235,000 articles are related to to NATO. Let's take another international organization, European Court on Human Rights. And as you see, it is 342,000. So All of this is way, way more than Interpol. So this is the first thing which I wanted to show you, just to understand how popular it is. It's not particularly popular. Now let's see the dynamics. What our system does, it shows you the intensivity of of mentioning Interpol in post-Soviet information space. So you see, in the lower part of the screen, there are the years, and as you see, there are some years, for example, 2014, when the representation of Interpol was quite bigger than the average level of the last years. But most of the years from 2005 until 2013, the level is quite low. Now, let's take the most vocal, most famous cases. This is, I don't want to read it once again, you can easily read it. So let's take just a couple of people with some comments. The last two cases were put forward not by Russia, but by the Ukraine and Georgia, respectively. So, let's take the first three cases and see what are the contexts from mass media. You see in what context these people are mentioned in regard to Interpol. Once again, I don't want to read it aloud, it's quite visible. Of course, you can click and have the full issue, the full text of the document. These are the next three people with some notes on the people themselves and with the quotes from mass media. So you once again immediately see the context. Now, so these are the figures which the system generates automatically for the research purposes. So, and you see quite a lot of zeros. It means for the whole month, not a single mass media title. Out of thousands and thousands of newspapers and magazines, TV and radio stations ever mentioned this or that person in regard to Interpol. Now let's switch to integral social networks. And as you see, this is 24/7 monitoring. You can easily set up your own topic. It could be somebody's name or the name of the company or just any combination of any words. And the system will pick up all the posts in social networks in regard to this. So, this is the context. Once again, I don't want to read it aloud. I don't know whether you can read it or not, or they're maybe too small, but it's quite interesting to see the context in social networks, what the bloggers, the users of social networks say about particular cases in regard to Interpol. So, you can see the full text of the post. You just click and it's opened. And once again, I just wanted to compare the number of or intensivity of discussion in social networks, different international organizations, Interpol, NATO, and European Court on Human Rights. So, as you see, Interpol is 3,000 plus, NATO is 71,000, and European Court of Human Rights is almost 9,000. So, the same tendency in social networks, once again, the Interpol cases don't ignite fierce discussion. It's definitely on the third place in comparison with other two. So, now let's see the comparison of all the posts in regard to Interpol and the posts where your people mentioned in the previous slides are mentioned in regard to Interpol. So as you see, definitely Mr. Saakashvili in social networks has position number 1 over Mr. Ponomarov, who is on the second position, and Mr. Yanukovych comes the third. This is month by month dynamics, which